All right, if you found this video, then it may be that you have been subpoenaed to testify against your significant other in a domestic violence charge. If they have been charged with domestic violence against you, you are a key witness for the state to show that that person is guilty of the offense. Now, I want to be very clear. This video is not legal advice. I want to explain what it means to be subpoenaed as a victim in a DV case and what that means for you if you are subpoenaed. You cannot have any defense attorney who represents your spouse giving you advice, though. If they give you advice, that is witness tampering. It is unethical. It is illegal. They cannot do it. What I want to do is just kind of explain the process so that generally people understand what is going on with these subpoenas. Again, it's not legal advice. If you have any questions, you should hire an attorney and talk with them to make sure that you're following all of the laws properly. Generally, though, in a domestic violence case, someone can be subpoenaed to testify against their spouse. Marital privilege does not apply in a domestic violence case because you are the named victim in the case. You are the one against whom the crime is alleged to have been perpetrated. Now, if you get a subpoena, a lot of confusion comes up in these cases because there's a difference in actually being subpoenaed or being asked to waive subpoena service. So that's what I want to go over here. An actual subpoena that can force you to go into court is a personally served subpoena. So in order for you to be forced to go to court, you have to be personally served with a document by someone that says, this is the court date, this is where you're being served to go, you have to sign it, they have to sign it, you have to be personally served. Now, technically you don't have to sign it, they can hand it to you and they can write that you were handed it, but basically a human has to personally serve you in order for you to legally be required to go to court. What often happens is, especially in El Paso County, we have such a large jurisdiction that the DA's office will send out these subpoena waiver postcards or subpoena waiver letters. It gets a little tricky, though, because when people get these letters and they read them, they see the highlighted portion that says you are required to appear at court, and they freak out thinking, oh my gosh, I'm going to get a warrant if I don't go to court. But if you read it carefully, in that language it will say, sign here to waive subpoena service. What that means is, the best way I can explain it is, think of it like an RSVP. I know that that sounds kind of trivial, but it makes the most sense in my head. So when you're looking at a waiver of subpoena service, it's like an RSVP. An RSVP is not binding on a guest unless they sign it and say, yes, I'm going to be there. So for example, if you're looking at going to a wedding and someone sends you an invitation and they say, please RSVP to let us know, you RSVP and say, yeah, I want the chicken. They say, okay, we know that this person is coming. And if you don't show up, they're going to be very upset that they paid for chicken for you to eat at that wedding. But if you don't sign it and you don't say I want the chicken and you don't send it back, they're not expecting you to show up because you didn't RSVP. So, same thing with a subpoena or a waiver of subpoena service. If the state sends you a waiver of subpoena service and you see the fine print that says sign and return to waive subpoena service, basically what you're doing is self-serving the subpoena on you. So, if you sign it and say, yes, you don't have to send somebody out to serve me, I'm going to be there, then you're legally required to go to court because you have waived that subpoena service. You have voluntarily served yourself for court. And if you send that back in and then you don't show up, they can put a warrant out for your arrest. But if you don't self-serve, if you don't sign that waiver, what you're saying is, no, I'm not going to do your job for you. You have to send someone out to personally serve me if you want me to come to court. Now, it's up to you how you want to handle that. Again, I'm just explaining the process and explaining what those waivers are. But it is very important to be aware of the difference between a subpoena versus a waiver of subpoena service. And practically speaking, in the state of Colorado, there are so many cases and so many charges, it is physically impossible for the DA's office to personally serve every single victim in a domestic violence case. So they send these subpoena waivers so that they don't have to have additional manpower for the investigators to go out and do it. It makes sense because there's no other way to get those subpoenas out to people. But if you are trying to decide whether you have actually been subpoenaed for court and you're trying to understand it, you need to know that unless someone personally serves you, you are not subpoenaed. Or unless you serve yourself by RSVPing and saying, yes, I will be there. If you have any questions and you are not currently a victim in a case where we're representing your significant other, I'm happy to give you any kind of advice that I can. We can set up a consultation. If you are represented by a client of ours, we cannot give you any legal advice, but this is at least an explanation of what's happened in the differences between subpoenas and subpoena waivers. We are also happy to give you a number of different attorneys, a list of attorneys in town that have criminal defense practices that may be able to give you some advice. If you have any questions, please reach out and we will do everything we can to connect you to the right person to get you answers.